To register a work with the U.S. Copyright Office, you generally must identify the author or authors of that work and the party that owns the copyright in the work. Ordinarily, the author is the person or persons who created the work you intend to register. Works made for hire are an exception to this rule. A copyrightable work is a work made for hire in two situations. First, when it is created by an employee as part of the employee's regular job, or second, when it's a certain type of work that's created as a result of a written agreement between the creator and a party specially ordering or commissioning it. For legal purposes, when a work is a work made for hire, the individual who created the work is not the author. Instead, the employer or the commissioning party is the author and copyright owner. Sometimes a person is clearly an employee, like a teller who works at a bank. Other times it may be less clear. To determine whether someone is an employee, you should consider several factors relating to the relationship between the person and the organization, including how the person is paid, how benefits and taxes are handled, and who provides the space, materials, or tools to create the work. For specially ordered or commissioned works, copyright law identifies 9 types of works that can be commissioned as works made for hire. And if they meet this requirement, the parties must expressly agree in a signed written contract that the work is a work made for hire. In either case, simply calling a work made for hire or paying someone to create the work does not make it a work made for hire. Circular 30 provides a complete list of factors to consider for determining whether a person is an employee and definitions for some types of works that can be commissioned. It also lists 7 questions you can use to determine if a work is a work made for hire. Let's look at some examples applying work made for hire principles. Buddy is a writer. Buddy wrote a sci-fi novel about turtles in space and published it himself. His novel is not a work made for hire, and he is the author and owner of this work. Buddy is an employee of the Turtle Preservation Company, where he receives a salary and benefits, and his job is writing reports for the company's publications about endangered turtles. These reports are works made for hire, and the Turtle Preservation Company is the author of them. Buddy also is a freelance writer, contracted once by the Ocean Textbook Company to write a textbook chapter about turtle nest. Before he started writing the chapter, Buddy signed a contract with the Ocean Textbook Company stating that the chapter would be a work made for hire. Buddy's chapter is a work made for hire, and the Ocean Textbook Company is the author of it. 3 different works, 3 different situations. 2 of them are works made for hire. So why does it matter? With a work made for hire, the employer or the commissioning party is the author and owns the copyright. The individual who created the work should not be named on a registration application. It also affects the term of copyright protection. For a work made for hire, it's 95 years from the date of publication or 120 years from the date of creation, whichever expires first. Also, termination provisions do not apply to works made for hire. For more information, visit copyright.gov.